Hello and welcome to the Refugee Study Centre at the Oxford Department of International Development. My name is Catherine Briddick and I'm an Associate Professor of International Human Rights and Refugee Law here at the RSC. Today, the 13th of March 2024, we welcome Francesca P Albanese, UN Special Rapporteur on the situation of human rights in the Palestinian Territory occupied since 1967. Francesca is also a Senior Advisor on Migration, Forced Displacement and Statelessness in the Arab World with Arab Renaissance for Democracy and Development, as well as an affiliate scholar of Georgetown University. She's an international lawyer with over 20 years of experience in the field of human rights and refugee protection, including with the Department of Legal Affairs of UNRWA, the UN Agency for Palestinian Refugees, and with the Office of the High Commissioner for Human Rights. She's published widely on the legal situation in Palestine. So Palestinian refugees in international law remains the preeminent text in the field. And two of Francesca's recent articles written with Lex Tackenberg on UNRWA and solutions for Palestinian refugees are published as RSC working papers and are freely available to read on our website. Thank you, Francesca, for joining us at such a challenging and busy time.
Thank you for having me.
So the seminar will proceed as follows. First, Francesca and I are going to discuss the situation in Gaza and legal responses to it. And second, we're going to take some questions from you, the audience. So if you have a comment, a question, or an observation for Francesca, please put it in the Q&A box. Francesca, I just want to start by asking you about your role. You're an independent expert. You're appointed by the UN's Human Rights Council. What is your mandate and how do you fulfill it?
So yes, independent experts of the United Nations are human rights experts, primarily but not necessarily lawyers, who have either a specific thematic expertise, for example, the Special Rapporteur on torture, on the right to food, on the right to health, the water, adequate housing, etc. Then there is out of the 55 special procedures mandate holders appointed by the Human Rights Council, there are 14 who have a country mandate. So they are requested to document, monitor, and report to the United Nations, in my case, both the Human Rights Council and the General Assembly, on the violations of international law that take place in that given territory. So my mandate comprises the West Bank, including East Jerusalem, and the Gaza Strip, so the territories that Israel has militarily occupied for 56 years. And then there are also a number of actions that by mandate I can take, for me it's the connection with civil society and with the media to make sure that the content of my reports, my findings, are as widespread as needed. Probably let me stress, Catherine, the importance of the independence, because we are appointed by the Human Rights Council and we do respond to the Human Rights Council only. So, for example, the difference between us and a special representative of the Secretary General, like the one who's these days in the news, the special representative on sexual violence, she's a political appointee by the Secretary General, and the Secretary General can decide also on her dismissal. In our case, the only one who can both appoint and dismiss is the Human Rights Council, and only for breach of the code of conduct that we all have to abide by.
Thank you very much. So I want to start by asking you about one of your most recent reports to the Human Rights Council from October 2023, and that's a report that focused on the rights of children. And I'm just going to quote a couple of sentences from it. So you observe that to advance the illegal colonization of the occupied territory, Israel has been subjecting the occupied population to a combination of daily deprivations, restrictions, and violence. You noted that Israel has deployed variable uses of force against a population under occupation, obfuscating the legal distinction between law enforcement operations and the conduct of hostilities, using both lethal force and collective punishment. Now, as we talk in March 2024, I was wondering what had changed since this assessment and what remains the same.
It seems to me, by listening to these words that were written 6 months ago, that we are looking at the manifestation of a tragedy foretold. Because for decades, those who have held this mandate, my predecessor, Michael Link, and his predecessors, Richard Falk and John Dugard, we have always denounced steadily some patterns of violations attributable to the settler colonial endeavor that manifests through the military occupation maintained by Israel, an apartheid regime that it's the inevitable manifestation of that settler colonial endeavor, and structural violence that I will explain. So what we are seeing today, like I would say the distortion of international law, the distortion of norms regulating the use of force, is displaying in its most lethal form, because what's happening in Gaza is not denied by the Israeli government or military. They claim responsibility for it, but they say that this is in line with IHL, because there are human shields that are legitimate targets, and everything they are destroying is to be destroyed because it serves a terrorist purpose. So this is the annihilation of the protection function of IHL. And yes, in my reports, I have pinpointed specific aspects of it. Now, but the report I wrote that I presented to the General Assembly that you referred to, the one on children, was particularly painful to write, because I did it. I cannot go to the occupied Palestinian territory. And for 16 years, no special rapporteur on the OPT has been able to enter the occupied Palestinian territory. At the same time, we have done our best to engage with forces on the ground, primarily human rights organizations, both Israelis and Palestinians, to collect information, being also accessible to victims. And I've done it a lot, also taking advantage of what was the silver lining of COVID, the fact that online meetings have become normal. And so I've interviewed dozens of kids over summer, and I concluded that their experience, their childhood under Israeli occupation, is an unchiding experience. So an experience that deprives children of the innocence, of the lightness of childhood. And this is because, and this I want to go deeper in the concept of violence. Violence, as experienced by Palestinians, particularly children, is both structural, because look at how the occupation operates. There is widespread military presence, particularly in the West Bank and East Jerusalem. East Jerusalem in the form of, police forces, because East Jerusalem is considered by Israel as annexed. And while Gaza has been blockaded, under siege for 16 years before the 7th of October. And so the violence is structural, is the taking of the land, the arbitrariness of spatial entrapment, but also the continuous digital surveillance and the deprivation of any exercise of fundamental freedoms, from taking residence, getting married, opening university, or going to university. Everything is controlled by the tight permit system. This situation is structurally violent. And then there is, of course, the violence that erupts both in the forms of when Palestinians resist, even peacefully. It's very easy to be arrested if you are a Palestinian in the occupied Palestinian territory, but also in the most, let's say, significant form, with proper wars. And this is what has happened regularly, particularly in the West, in the Gaza Strip, where there were 5 wars before 2023 that have killed 5,300 people, including 1,200 children. This is why I say, without condoning what Hamas has done on the 7th of October, Hamas and others have done on the 7th of October, there were many 7th of October for the Palestinians. And unfortunately, that call for justice that was also supported by us special rapporteurs was not heeded by the international community.
So earlier this year, South Africa brought a case to the International Court of Justice against Israel seeking provisional measures in relation to the Genocide Convention. And the court found that the legal conditions for indicating provisional measures were met because it was plausible that genocide was being committed in Gaza. The court, in reaching this assessment, drew on the work of a number of expert reports, UN agencies, statistical information, including the work of UN Special Rapporteurs. Do you agree with the court's assessment here?
I do. And in fact, I was surprised, but happily surprised, that the court had relied on our assessment. There have been about 30 special rapporteurs, and I can tell you, I was not even the first one to see how the acts that were being committed, how the logic underpinning this latest military assault could be genocidal. But then, I mean, among us special rapporteurs, also there is a sort of space for self-learning. So this is something that we have studied together, and we have warned on the risk of genocide, the severe risk of genocide, and the fact that there was a genocide unfolding within a month since the 8th of October, the start of the assault, because not just because of the amount, I mean, because of the numbers of the people killed, and the fact that 70% of them have steadily been women and children. There have been 13,000 children killed in 5 months, which is the highest number than all children killed in the worldwide, in all conflicts worldwide in 4 years. But it's not just because of the killings, because we could say, oh, maybe this is a war crime. It's the widespread destruction. There have been all universities, hundreds of schools, three-thirds of the hospitals destroyed, while the rest is also malfunctioning. There has been a tightening of the siege that has prevented entering of essential supplies like water, food, at the time also life-sustaining infrastructure and realities like the fleeting, the fishing float or the arable land in Gaza was destroyed. There has been 70% of Gaza that has been erased forever. Entire generations killed. And this is the thing. Is it just a collection of war crimes or crimes against humanity? In my view, one is to look, as it is for genocide, at the intent. And Israel, because of that conflation that you asked me at the beginning, between various categories of IHL, and because of the distortion of IHL, what is considered a military target, what is considered acceptable collateral damage, what is considered military necessity. Israel has nullified all this, erased all this, and justified, in fact, its conduct, because it's underpinned by a genocidal logic, destroying, and which is resulting in the destruction of a part of the population. 4.5% of the people in Gaza have either been killed or are reported missing or have been severely injured, and I mean, will be either mutilated or injured for life.
So the court indicated provisional measures in response to this particular threshold being met. And when it did so, it didn't follow approach that it had taken in its other case law. So in a case brought by Ukraine against Russia, it ordered Russia to cease military operations altogether. And the ICJ did not make a similar order here. Instead, it made it indicated a series of provisional measures in relation to the investigation of acts which may constitute genocide, and in relation to constraining the armed forces. What's your analysis of these provisional measures? Are they enough, do you think, to offer the people of Gaza sufficient protection?
Yeah, let's say those who took the time to really consider what the ICJ had said, because we have to recognize that Israel did its best to divert the attention from the ICJ interim ruling, because the day after the ruling was rendered, there was a campaign, a heightened campaign launched against UNRWA that distracted the defunding, which resulted in the defunding of UNRWA by 18 member states. So this has distracted many. But those who stayed focused and looked at what the ICJ had said, I was positive. I welcomed the together with other rapporteurs, I welcomed the finding of the measures recommended by the court, knowing also that the case was different from Ukraine, Russia, because the question of aggression was not to be considered, was not one under consideration by the court. It could have said, it could have ordered a ceasefire, but it would have been odd considering the legal framework referred to was the Genocide Convention. So the court limited itself to make recommendations that make sense to prevent acts of genocide. So it rejected Israel's request to dismiss the case. So it recognized the plausibility of the risk of genocide, it said it, and it recommended measures that, had they been fully observed, they would have resulted de facto in a ceasefire. This was my assessment, and others as well.
And do you think that, so we've got obligations being generated for Israel in relation to these provisional measures. Are there obligations for third states here as well? And are they being complied with at the moment?
Yeah, the rulings and the measures recommended by the courts are binding on other states as well. So the fact that Israel has, in my view, not complied with the requirements of the court, because the court, can I go through the measures briefly?
Please, yeah.
Yeah. So the courts recommended Israel to take all measures in its power to prevent commissions of acts of genocide, meaning the killing, the indiscriminate killing members of the group, the creation of conditions that would make life of the group or part of it impossible, the infliction of severe bodily or physical harm. This has not stopped. These acts have not ceased. On the contrary, they have continued in the aftermath of the ICJ's orders. There have been massacres. There have been the population has been further pushed toward the south. It's amassed. We have 1.5 million people amassed in an area that normally is inhabited by 300,000 people, which has been bombed as well. There have been gruesome cases being reported, and let's say also that the Israeli army is sharing a lot on social media of its conduct on the ground. There has been the shelling and killing of people trying to gather for food. At the moment, like 2,200,000 are starving because it's 5 months without food. The other thing is that so Israel has not complied with this. The court also recommended to take immediate and effective measures to provide urgently needed humanitarian supply and humanitarian aid. And not only Israel has not honored its obligation under IHL to provide humanitarian assistance and access to relief to the people in Gaza, it has also hampered humanitarian aid provided by others. There are over 1,500 trucks blocked at the Rafah boarding with Egypt. And the access points between Gaza and Israel are also closed. So there is nothing that comes in. This is another way of non-complying with the order. The other thing is that the court had ordered to prevent and punish directed public incitement to commit genocide, and nothing has been taken. No measures have been taken in this respect. On the contrary, just a few days after the order, there was a conference where a number of Israeli ministers, government ministers participated and advocated for the voluntary migration of the Palestinians in Gaza elsewhere. So there is this forcible displacement narrative that the ICTY, for example, found that might constitute genocide. I mean, ethnic cleansing might constitute genocide. So there has been a negligence and also a clear violation of the measures ordered by the ICJ. And so there is a responsibility of Israel, who also had to submit the report within 1 month, yes. And the report has been submitted, but it is not public. There are 3 pages that have been made public, but they don't say much other than restating that Israel is an IHL abiding state. But the thing is that there is solid jurisprudence that recognize the responsibility of third states when they have knowledge that acts of genocide might be committed, and they don't take all measures in their powers to prevent this act. Here, in this case, we also have states who are enabling Israel's conduct, because we have the US who have continued to provide not only political but material support, financial support, and weapons at the time that an arms embargo would be compulsory in order to comply with the ICJ measures. So there is already a case that has been filed against the US for complicity in genocide, and I suspect that in the coming months we will see more of this, because also there has been a revolt among civil society worldwide for what's happening in Gaza, and people demand justice.
Thank you. You mentioned the distortion of international humanitarian law. And I just wanted to ask you what you felt that the Office of the Prosecutor of the International Criminal Court, or what the International Criminal Court, could and should be doing at this point, given the ICJ's findings in relation to genocide, and the fact that we know that the ICC does have jurisdiction over the situation in Gaza.
Yeah, my impression is that the International Criminal Court, well, this is not my impression, the International Criminal Court is absolutely late in delivering justice in the context of the occupied Palestinian territory. Because I hear that now they are investigating the commission of war crimes, but war crimes were already being committed before the 7th of October. So now they are focusing on what has happened out of the 7th of October, which is great. I mean, it's more than due. All warring parties that have committed crimes that fall in the jurisdiction of the ICC should be investigated and prosecuted. At the same time, the court has taken such a long time to look into the war crimes that Israel was being committing. Think, for example, of the settlements. Settlements are a blatant violation, a flagrant violation of international humanitarian law, Article 49 of the Geneva Convention, and it's a great breach of the Geneva Convention. And this is an endeavor that Israel has engaged with for 56 years. Why the court has never indicted anyone, even at the time, like in 2023, the Israeli government issued a government plan announcing the annexation of large swathes of the West Bank. So it seems that the court somewhat has given in the pressure coming from member states, not to, particularly the US and other European countries, not to ever investigate Israel. Now the situation is pressing. I think that they are seriously looking into it, but my sense is that they might still remain within the parameters of war crime. I don't see any from my perspective, I don't see them acting swiftly on the genocide case as they should, because in other cases the determination of criminal of individual responsibility, of criminal liability, played hand in hand with the determination of state responsibility or a non-determination of state responsibility under the ICJ.
Thank you. International humanitarian law, it obviously envisages civilian casualties and deaths, and it envisages destruction, and it envisages displacement. But what it also does is seek to act to constrain states' conduct. Looking at these different legal processes and the distortion that you have characterized, is there any sense in which IHL or these processes are constraining Israel's actions at the moment? And given your comments earlier, I mean, what are the consequences if IHL isn't operating in this way, both for the people who's come under your mandate, so people whose human rights are affected, but also for the international rule of law more broadly?
Yeah, something that I've said from the very beginning is that the violence of the ongoing operation in Gaza was started on October 8, risked to bury forever the protection function that IHL had. And if not addressed, creates a precedent that it's, again, the denial of the minimum, of the bare minimum of humanity that IHL is there to guarantee. Because it's true, I agree with you that IHL does not rule out the possibility of civilian casualties. And therefore, it's not the most protective framework, but it also in legal framework, but it also operates in situations of emergency. The question is that in the occupied Palestinian territory, that term emergency has been expanded over more than a decade, more than 5 decades, and has become the basis to interpret what is legal and what is not. So the entire Palestinian population has been considered and is considered by Israel as an hostile entity, as an enemy population, while these people, as a protected group, both under the Genocide Convention and protected as civilian population under IHL, should have been protected. Instead, they have been considered, they have been presumed guilty until proof of innocence. This is what I've observed throughout the various reports I've written. And again, this is extremely dangerous because it gives the margin to any state who claims to fight a terror organization to level all safeguards to protect the life of civilians. And let me give you an example. I was listening yesterday to an interview by Australian journalist John Lyon, whom I really like, and he was interviewing Israeli ministers, former ministers, and security personnel, and they were saying, well, to the question, but yeah, but how did you manage? How did Israel manage to kill 13,000 children? And they say, well, but this is inevitable because they are there. Yes, of course they are there. They've been trapped there for 16 years, and even now there are no humanitarian corridors. These people cannot flee, so they have entrapped an entire population, bombed them from north to south, giving evacuation orders to 1.4 million people. So you see the legal terminology, evacuation orders. And evacuation orders is legal. You can, as an occupying power, evacuate the occupied population, but not 1.4 million, because, and you cannot say that whomever doesn't comply with the order will be considered Hamas affiliate or a terrorist, because again, you see, so the evacuation order has been used this way. The 400,000 Palestinians who could not leave, could not comply with the evacuation orders because they were sick, because they were caring for sick people, because they were doctors, nurses who didn't want to leave the hospitals, because children are being subjected to horrible practices, including torture and other inhumane and degrading treatment that starts to be documented in a coherent form. And meanwhile, Israel has created safe zones. Again, unwelcome. It's an IHL concept, but first and foremost, safe zones have to be agreed upon by the warring parties, so that everyone knows where the protected people have to be told to go. In this case, Israel wrote a map, told the people where to go, but then without electricity, without access to mobile phones, because this is how Israel communicated, this grid that was telling people where to go, without them understanding where, because the grid is not necessarily something a person can relate to. And so there's been bombing of and shelling of safe zones, just to give you some examples of how international humanitarian law has been distorted.
Thank you very much.